بسم الله الرحمن الرحيم الحمد لله رب العالمين وصلى الله وسلم وبارك على سيدنا ونبينا محمد ذي القدر العظيم وعلى آله وأصحابه وأتباعه إلى يوم الدين. اللهم فقهنا في الدين وعلمنا التأويل وألهمنا رشدنا يا رب العالمين. Alhamdulillah. In our sessions on the Mukhtasar of Imam Quduri, from the section on mu'amalat, on financial transactions, we began looking last week at the chapter on admissions, iqrar, and we paused towards the end of the chapter when there's the issues related to al-iqrar, the iqrar related to lineage, admissions related to lineage. Right? Now, a key thing to appreciate is that not every admission is an admission, right? Right? That when it comes to a child, for example, imagine if someone randomly comes and says to Zubayr, "You're my child." Is that acceptable? No, because he already has an established lineage, etc. Right? Or someone goes to a lady and says, "I admit she's my wife." Does that establish that she's his wife? That's a claim. So they always, when it comes to iqrar, one has to consider, is this an admission or is it a claim? Because sometimes a claim is actually an admission, explicitly or implicitly, and sometimes an admission is a claim. In terms of, like, what is and the key is to consider what kind of right is mentioned. So, let's look at that, bi'idhnillahi ta'ala. So, Imam Maulana al-Imam Al-Quduri rahimahullah says, وَمَنْ أَقَرَّ بِغُلَامٍ يولد مثله لمثله وليس له نسب معروف أنه ابنه وصدقه الغلام. What? Sorry. One issue before that. My apologies. Let's go back. قال الإمام القدري رحمه الله ومن أقر لابنه. Right? And properly speaking, there should be a paragraph there in our copies. Right? It's on the copy. Right? The paragraphing is completely random. ومن أقر لأجنبي في مرضه ثم قال هو ابني. Someone admits that a stranger is his child. Now, what's the problem with that? There are other inheritors involved. So this, of course, assuming that this person doesn't have a nasab, doesn't already have an established lineage, etc. The problem is, this could be one way of giving someone more money, giving someone money, and of depriving inheritors. Right? Right? He says, so whoever makes an admission regarding an ajnabi, an unrelated individual, in their fi maradihi ay fi maradi mautihi, in their final sickness, and then says, he's my child, and of course, then what happens? right? وَمَنْ أَقَرَّ لِأَجْنَبِيٍّ, right? So one admits that you owe مَنْ أَقَرَّ لَهُ, أي مَنْ أَقَرَّ بِحَقٍّ لَهُ, right? So whoever admits لِأَجْنَبِيٍّ بِحَقٍّ, right? Whoever admits that they owe a right to an unrelated person. In their final section, ثُمَّ قَالَ, then they said, he's my child. So there's two things going on. Say, Zubayr says, I owe Hamza, not forget Hamza, right? Some other, I owe Bilal $5,000, and he also says he's my child. Right? So what happens? ثبت نسبه منه وبطل إقراره له. Right? Now, there's a few things. Firstly, the one being admitted regarding, the commentary mentioned, وَصَدَّقَهُ الْمُقَرِّ لَهُ. The person, the admission is made regarding, accepts this claim. Number one. Right? Number two, وَكَانَ بِحَيْثُ يُولَدُ لِمِثْلِهِ. And it is such that the like of them are born to the like of them. Right? And these kinds of things require verification. Right? It would require verification. Why? Because يَتَعَلَّقْ بِهِ حَقُّ الْوَرَثَةِ. So we'd have to check, was he, of course, الْوَلَدُ لِلْفِرَاشِ. We have to keep in mind the hadith of the Prophet ﷺ. Right? This one, الولد للفراش, right? That a child is ascribed to what? To the married. Literally, the child is for the bed, but what it means, الولد للفراش, a child, the lineage of a child is ascribed to the marriage. So something like this, ما تعلق بحقوق الورث, in general, ما تعلق بحقوق الناس فلا بد فيه من الاحتياط. Anything that relates to the rights of others, it requires caution. And mirath, inheritance, requires particular caution. Because Allah subhanahu wa ta'ala has laid out the rules of inheritance Himself explicitly in detail out of the necessary caution because of the impact inheritance has on families, and out of divine wisdom as a test. It has two aspects, right? So there we'd have to say, the person has to accept it. So first we'd have to say, does he presently, the person you say, the person, I owe him $5,000 and he is my son. The 5,000 is accepted. The da'wah would be accepted if the da'wah of nasab is not accepted, if the claim of lineage is not accepted. But if the claim of lineage is accepted, then what happens? The claim of owing him the money would not be accepted unless the other inheritors accept that. Now, a claim of lineage, the issue is that the claim of lineage is not actually being made now. They say تستند إلى وقت العلوق. It is ascribed to the time of conception. However, we would need to, what's the caution? We have to verify, was he married at that time? Right? Not every court case is handled at the moment. So we would have to, number one, check, was he actually married at that time? Right? Can he establish that he was married at that time, either by the wife admitting to it, or if the wife died, family of the wife, or the witnesses, which is why having witnesses is important. Right? We have to verify this claim because it relates to the rights of people, right? If all of that is established, and of course, يعني لا تقبل دعوة يعني يكذبها الظاهر. A claim, is only accepted, or a claim is not accepted if the outward does not negate it. The person already is considered to be someone's child. So we'd have to also establish the person was previously considered walad zina, right? Or did not have a known lineage, etc. Right? So there's a lot that is implicit in this issue, right? If all of that is established, then the claim for this ajnabi is not accepted. Okay. Allahumma salli ala Sayyidina Muhammad wa ala alihi wa sahbihi. Right? So if the lineage is accepted, بطل إقراره له. Then the admission of إقراره أي بالمال, then the admission of owing him something would not be accepted. ولو أقر لأجنبية, right? If one admitted to owing something to an unrelated woman, this is all in what? في مرض موته, in his final sickness. Right? ثم تزوجها, then he married her. لم يبطل إقراره لها, then his admission to owing her money would not be negated. Why? Because the admission took place first. So the problem is that, in the final sickness, the wife inherits, correct? The wife inherits. The children inherit. You cannot, giving money in the final sickness to one of the inheritors is problematic. But if you did this when already married to her, that I owe my wife money, and you cannot, and as we took last, you have to show an outward sabab, right? That you can prove that we have an existing debt. I owe her this, that, that's a separate thing. But this is لم يبين السبب. You did not mention the cause. So here, she was unmarried to him. He says, I owe my neighbor's daughter $5,000. So she came to visit that, yes, he owes me $5,000. And she said, I don't want you to die a single man. I'll be married to you. I'm studying for my medical exams anyways. So in this last week of life, she got married. And some of the women of the Salaf did things like that. And there's people who got married on their deathbed just so that they did not meet Allah subhanahu wa ta'ala single. There's some very interesting cases of stuff like that, right? So anyways, right? And Allahumma salli ala Sayyidina Muhammad. So the admission took place when she's a stranger. Then he married her. The previous admission is not invalidated unless we can establish collusion or they hid the marriage first or anything like that, right? Because lineage is established from when? From when the conception took place, or when the birth, when the conception took place, right? But marriage is established from when the marriage took place. So when he made the admission about that third party, that he's my son, that I owe him money, he's my son, he admitted to him being his son after. But if that admission is accepted, it is ascribed not from that point, but it's ascribed from conception. So, if that's accepted, the claim is invalidated that I owe him money, because you cannot admit to owing money to one of your inheritors. But in the case of marriage, right, he married her he admitted to the ajnabiyya, the unrelated woman. He said, I owe my neighbor's daughter money. Then he married her. So he admitted to owing money to a third party. She only became his wife after, so the admission is valid, and it's unaffected by the marriage that took place afterwards. Clear? Right? And this is why these examples are best understood by, coming up with a case, like we mentioned, right? The neighbor's daughter, for example, or whatever. Another case. ومن طلق زوجته في مرضه ثلاثا أو أقل, or even less, ثم أقر لها بدين ومات فلها الأقل من الدين ومن ميراثها منه. Right? And this is because people try to cheat. Right? He's dying. He wants his wife to get more money. So he says, look, I love you, you love me, but let's play a trick on the others, right? And this is why some people, of course, this has to do with inheritance, but there's a wisdom why Allah subhanahu wa ta'ala has made a general rule on inheritance, regardless of the specific case, in order to avoid disputes within families, right? This is something Allah, there's an aspect of ta'abbud in it, and an aspect of avoiding dispute, right? Of who gets how much. If there are very specific scenarios, then you need the time to deal with it is during your life. Right? A disabled child, this, that. Make arrangements regarding them in your lifetime. And also you're relying on the decency of the other children to do something about it. But so what's the scenario? من طلق زوجته في مرضه ثلاثا. Someone divorces his wife in their final sickness 3 times. Or less, with her requesting it. So it's a talaq ba'in, right? Then he admits that he owes her money and dies. And it's an important thing that وَهِيَ فِي الْعِدَّةِ, right? While she's still in her iddah. Because if you admitted to her to owing her money while sick, but her iddah finished, then she only inherits from him if he divorced her and her iddah is still not finished, right? Because once the iddah is finished, the marital relationship is over. That's one of the several wisdoms of iddah. That, and this is called talaqul far, the talaq of the one fleeing from someone. Zubayr ended up hating Zubaydah, right? So what does he do? Finally, he doesn't want her to get money. I love my kids. Someone says, I love my kids, I hate my wife. Few minutes before death, he divorces his wife. As long as she's still in the iddah lasts, takes a while, she still inherits. But he divorced her 4 months ago. Once the iddah is finished, what is the ruling of the marital relationship between them? It's finished. So therefore, she wouldn't inherit from him, right? Here, he divorced her, admitted to owing her money, and died while she's still in the iddah. فلها الأقل من الدين ومن ميراثها منه. She gets the lesser of the two amounts, of the debt or the inheritance. Because both could have ulterior motives in this. Right? Because they might be using the divorce simply to get her more money. Right? If she would get the money and the inheritance, then say, oh, I owe her $5,000. I owe her $500,000. And she's already divorced. Says, no, if she's still in the iddah, right? Right? And the commentator says, we said this is if the divorce was threefold or she asked for divorce and the iddah is still in place, because without her asking for it, because if she didn't ask for it, then he would be clearly fleeing from his responsibility of mirath, right? Right? Because if he divorces her, and the iddah remains, she gets her share of the inheritance, however high it is, and the admission would not be accepted. So this you need to diagram if you want to understand it, right? That if he divorces his wife during the iddah, if he divorces his wife first, then admits to owing her money, like owing her a debt, because there's no proof that this debt arose before the final sickness, right? If he divorced her 3 times, that's a final divorce. If she asked for it, then he is not the one who is trying to get rid of her. These are 2 cases. A threefold divorce is terminal. If she asked for the divorce, then he didn't divorce her. If the iddah remains, so if someone could take on diagramming this for us, it would be very useful. If the iddah remains, then what happens? There could be some kind of collusion between them to try to get some money for her. But if it wasn't a threefold divorce, or if she didn't ask for the divorce and the iddah remains, then she gets her full inheritance and the admission would not be accepted. The admission would not be accepted like any other inheritor. Right? If the iddah is over before he dies, then the admission is accepted, and what happens? She's no inheritance because her iddah is over, they're separate. Someone could diagram this, would be very nice. Someone had himma, they would diagram all of Quduri, but okay, now we get to the ghulam. وَمَنْ أَقَرَّ بِغُلَامٍ, whoever admits to a child, يُولَدُ مِثْلُهُ لِمِثْلِهِ, the like of which would be born to the like of them. وَلَيْسَ لَهُ نَسَبٌ مَعْرُوفٌ, and the child does not have an established lineage. Then what's the admission? أَنَّهُ ابْنُهُ, and the saying that this is my child. وَصَدَّقَهُ الْغُلَامُ, and the child admits to it, right? Because there's an interest in the child. If the child's reach an age when they can express themselves, the child says, he's not my father. Then then other proof would be then the claim, right? That would not be an acceptable claim for obvious reasons, right? Because the child has something of an interest in who their parent is, right? As is obvious. ثبت نسبه منه, right? Their lineage would be accepted, right? Their lineage would be accepted. This is in general. وإن كان مريضا, but what if the one making the admission is in their final sickness, right? مريضا, in this, what is meant? In مرض الموت, right? The relevant sickness, مرض الموت. يشارك الورثة في الميراث. They would share with the inheritors in the extent of the inheritance, right? But if the inheritors challenge it, right, then more verification would be required, right? But it's possible, things happen to people, right? Real life things. Someone got married in one land, their wife died, then they moved to another land. A lot of people have complicated things. I personally know people who had a child from a first marriage and they don't talk about it even to their subsequent wife. They, family, life moves as if it never took place, right? And they never get around to telling their kids. It's a mess. So it's very possible. But if it is challenged, then we'd have to verify the facts. But because in order for that child to be his, it would need, what does it need? Who are you married to? Can we verify that? All those things would need to be verified, right? And that's why court law, this is dealing with the basic structure of the claim, not all its component details, right? For obvious reasons. Now, what happens in the absence of an Islamic legal system? This is why people need to keep living wills. Living wills. And if there are things like this, then it is your moral duty, because if, let's say there was this case, Zubair, before he married Zubaydah, nobody knows. Zubair got married at the age of 18. He never told Zubaydah because he never married him. And he had a child. And then the marriage failed. So he has this child. He never admitted to that child. Of course, child arose out of marriage, etc. So these things have to be addressed. But because we have to consider the interests of that, because there's a possibility that there's truth to this, yes, and there's the inherent, and it is one of the things that the Sharia came to preserve. The maqasid of the Sharia, some mention there 5, some mention there 6. حفظ الدين والعقل والمال, حفظ الدين والحياة, حفظ الدين والنفس والعقل والمال والعرض والنسب. And some distinguish between, so preservation of religion, life, intellect, wealth, honor, and lineage. Some consider honor and lineage as one, some separate between the two. But it's a fundamental right for someone to have a lineage where feasible. So an interest of the child there. And there's the and there's the interest of the inheritors. And the role of the judge is to give everyone who has a right their due right, and no one party wronging the other. Hasb al-Zahir, according to the rules of the outward. In the absence of a court system, we have to have adjudication systems in our own community that can address these matters, particularly when these matters would not be addressed by the law, so that rights can be preserved, right? And the Prophet ﷺ warned, the first of the knowledges that will disappear from the ummah is knowledge of inheritance. But it's not the knowledge if it would disappear as mere knowledge, but rather that the acting upon that knowledge will disappear. Knowledge will disappear insofar as it's rarely taught to people, but that it's rarely practiced, right? And in 18 years of answering questions online, it is scandalously shocking how rarely people ever submit questions on matters related to inheritance. And it's not because there's so many people addressing them. And that's a big, big issue, and we'd all personally need to consider that, and there has to be active effort to address these matters. But it's also, true spirituality is, what is a person of spiritual accomplishment? The people said, the ulama said, as-sufi faqihun amila bi'ilmihi. A person of spirituality is a person of deep religious understanding who acted upon their understanding. فَأَوْرَثَهُ اللَّهُ عِلْمَ مَا لَمْ يَعْلَمْ. Right? So this is something, very important. ويجوز إقرار الرجل بالوالدين والولد والزوجة والمولى. Right? It is permitted, it is valid for a man to admit to having parents or a child, or a spouse, or a master, because this is admitting to what do you have something different? Okay, to something that he owes, and you're not establishing a lineage for somebody else. ويقبل إقرار المرأة بالوالدين. Right? It's valid for a woman to admit to having parents, or a spouse, or a master. Right? ولا يقبل بالولد. But her admission to a child is not accepted. Because by saying, this is my child, you are claiming that, by doing that, you're claiming that that child has a lineage for someone else. Because you cannot just claim a child as yours. Islamically, again, the same hadith applies. Al-waladu lil-firash. One is a child religiously yours when it's from marriage. Right? That's when lineage is established. Right? A child born out of wedlock, right? It's your child biologically, but it's not your child legally. The child born out of wedlock does not inherit from his or her parents. And in that is a clear harm to the child. That child does not inherit from the parent. lineage is not established. And the wisdom behind that is to make clear the grave harm of the spread of zina in society. This is a zina destroys society. It's simple as that. It destroys society not only morally, but it destroys civilizations, because civilization can only, any society or civilization can only remain as long as the institution of marriage remains healthy. Otherwise, the society will not, if zina becomes widespread, they won't be able, there'll be moral decay, but there'll also just not be intergenerational preservation. Right? And you see that in many parts of the world already. Like there are serious fears of just straight up population implosion. Why? Because to do with lack of marriages, and because people typically have children out of marriages, and at least to be at a level of societal maintenance and being the divine command. So her claim on her own that this child is legally hers, meaning that this child was born to her out of marriage, then you have to say, who are you married to? If that person admits it too, then it would be accepted, right? إلا أن يصدقها الزوج, unless the husband, the claimed husband, accepts it. Because she says, this is my child legally. Because if she just said, he's my child biologically, that is not sufficient to establish legal lineage for the purpose of inheritance, unless the husband admits. أو تشهد بولادتها قابلة, or the nurse who helps assist in delivery, what are they called? Or the midwife, right? But قابلة could be midwife or nurse, right? Or the hospital record shows that this child is hers, but we still have to establish the fact of marriage, right? For the reasons mentioned. Right? And in childbirth, the word of one woman is sufficient, because typically, because it's common for there only to be, or would historically be common for there to be one midwife present. Right? So matters related to establishing a child's birth, the opinion of one woman would be sufficient. But the ulama would say that it's better for there to be more than one person present at the time of childbirth, just if things arise. And it's highly praiseworthy for that person, for a midwife, to be chosen on the basis of at least of moral uprightness, and ideally uprightness, because there's rulings related to that, but also of righteousness, because there's a legal dimension and a spiritual dimension, right? Because this person should be giving spiritual support during the time of marriage, and also uprightness, because there are legal rulings related to childbirth, right? In terms of extent of exposure of the awrah, praying during childbirth. There's religious rulings, but also spiritually of reminding to remember Allah subhanahu wa ta'ala, etc., etc., etc. So that's also of the areas that is very frequently neglected. People take care of everything to do with childbirth, even which type of medication they'll use and not use, and spend hours researching that. People don't spend even minutes thinking about what are religious rules related to the childbirth and what are spiritual. How do I approach the childbirth spiritually? And they're both very significant for the person giving childbirth, the woman, and also very significant related to the child, because that's how the child enters the world. Child enters the world, the mother missed several prayers and was completely heedless of Allah subhanahu wa ta'ala, but was following very carefully all these preferences. Will I use an epidural? Will I do this? Will I do this? Will I do this? What kind of flowers will I have next to me, and what perfume there will be, and all these kinds of things. Okay? How things are is profoundly affected by how they begin. ما أشرقت بدايته أشرقت نهايته. Right? Anything whose beginning is illumined, its ending may well be illumined. من علامات النجح في النهايات الرجوع إلى الله في البدايات. From the signs of success in endings is returning to Allah in beginnings. Right? So, and of course, in these issues where the man says that these are my parents, they have to accept it. Right? So someone goes and says, these are my parents. What's the assumption in the ruling? And the commentator makes clear that they say, yeah, he is. Right? And there has to be intifa' al-mawani', that he didn't already have an established lineage. Because otherwise, then we have to go and disprove that. Right? So there's a lot that is unstated there. Right? ومن أقر بنسب من غير الوالدين والولد والزوج والزوجة والمولى مثل الأخ والعم لم يقبل إقراره في النسب. Whoever admits to a lineage, right, of other than being of a lineage, meaning a family relationship of other than someone being their parent or their child or a spouse, husband or wife, or someone being their master, and of course they have, such as saying that so and so is my brother, meaning, or my sister, or my uncle, or my grandfather, then that claim is not accepted. Because first, for me to say that Bilal is my brother, what I have to establish is that Bilal's father is my father, or Bilal's mother is my mother. Or Bilal's father is my father. Right? That's what I have to establish. Right? فإن كان له وارث معروف قريب أو بعيد فهو أولى بالميراث من المقر له. Right? So in this case, if they have an inheritor who's known, whether close or distant, of those who are eligible to inherit, then that person is more deserving of the inheritance than the one being admitted to. وَإِن لَمْ يَكُنْ لَهُ وَارِثٌ استحق المقر له ميراثه. And if they don't have any known inheritor, then the one being admitted to then deserves the inheritance. Meaning, somebody has no inheritors, and they admitted to someone to being related to somebody, then that person does become deserving, because then it's your money. You're basically saying, give my money to so and so. Right? It's in the case where someone has no known inheritors, and they claim a lineage to somebody, even if it's not fully established. That's just like saying someone dies without inheritors, and they say my inherit, give my money to so and so. Then that's given, and we'll see the details of what's done with that when we come. That what happens to the wealth of someone who does not have a known inheritor. One of the cases of that is if someone entered Islam, right? And they did not get married nor have children, and their parents did not enter Islam, for example, or their children didn't enter Islam, that they did not leave a will ومن مات أبوه فأقر بأخ لم يثبت نسب أخيه. If someone's father died and then the person whose father died says, I have a brother, meaning this brother is from the same father, then the brother's lineage is not established just by mere claim alone. It would require proof, right? وَيُشَارِكُهُ فِي الْمِيرَاثِ, but this person would share in the inheritance, right? So why? Because the commentator explains, لأن إقراره تضمن شيئين, because this admission had two things within it. By saying, he is my brother, you are claiming, you're ascribing his lineage to somebody else who cannot, having passed away, can neither affirm nor deny it. And your claim, an admission that's a claim against somebody else is not accepted. Zubayr says, Zubaydah is my wife. She would have to accept that claim, right? Similarly, someone says, Bilal is my brother and the father has passed away. He can't defend himself now. So that claim, that admission is a claim against somebody else with respect to their rights, but they can't. But by saying he's my brother, you have by indication also implicitly claim that some of the money from that person belongs to him. So you are foregoing your share of the inheritance. Now, if in court, someone would tell you that, by the way, by making that claim, this is what it entails. Are you aware of that? Yes. Then you are foregoing your right by making that claim, right? And this all, of course, applies in court or the like. So this has to do with claims. These claims are played out in court, and there are many nuances to them. So this will take this extent of that, bi'idhnillahi ta'ala. Then he says, Kitabul Ijara, the book on hires. Any questions? Okay. Bismillahir Rahmanir Rahim. Kitabul Ijara. Right. Omar, we'll split this lesson into two parts. Okay. Kitabul Ijara. The chapter on hire or leases. Right? Ijara, how did he translate it? Lease. Okay. It's Ijara covers hiring a person or leasing a thing, right? The fundamental contract is Aqdul Bay'a. The foundational contract is the sales contract. Why? Because the core concepts of contracts arise in the sales contract. But and it's also the easiest contract to conceive of. Why? Because its elements are tangible. There's a buyer, there's a seller, there's an item of sale, and there's a price. And then there's the details related to the contract. But because what's the subject of a sale contract? The item of sale. Correct, right? It's tangible. So the ulama deal with the sale contract first, because it's tangible. All other contracts are derivative. Even a marriage is a contract. Now some people, and the reason it's important, because a marriage also, there's two transacting parties and there's something that is being transacted. So the ulama use the concepts learned from the sales contract to marriage, but nobody is selling themselves to the other in marriage. Right? The comparison is being made insofar as that there are two transacting parties and there's something that each party is giving in that. Right? And consequences arise from it. Nobody is saying that, so there are, and this is where you have to be really careful. Right? People spend 3 to 5 years writing their PhDs to have a lot of time to concoct theories. And some people write, and sometimes religious people, right, or who used to be religious, right, concoct the most absurd theories related to that marriage is a type, like they'll say things like, in marriage, a Muslim woman enslaves herself to the husband. And that's absurd. Because the fuqaha said that, no. That what someone owns there is there's a right that arises for both parties in the marriage, right? And there are a whole bunch of associated concepts, right? So this is important. And it also ignores that there's law and there's ethics. There's law and there's ethics. So, for example, the fuqaha say that if someone says, I buy you for $200, would that marriage be valid? Someone says, I sell myself to you for $5,000 in the marriage contract with witnesses. Would that be valid? Now, the fuqaha are not there to give admonition. Right? And the reality is that Islam came not just for the learned and the educated and the aware. As Abraham Lincoln said, God loves the common man, that's why he made so many of them. People make all kinds of absurd things. Some couple decide to be dramatic. Zubaydah says, I sell myself to you. I am yours. He says, you are truly mine. I hereby take you for 10,000. They made some dramatic, like as if it's a play. Okay. When all is said and done, they go to the faqih. Now they have 2 children. Was that valid? So you say, yeah, it's valid. Get out of here. Right? But it's against the sunnah. Right? It's against the sunnah. Which is why you don't teach people just the limits. Because the sunnah of how the marriage is conducted, but if it's done. But if someone says, I rent myself to you, it would not be valid for obvious reasons. That does not convey the meaning of, that's prostitution, right? And it's not allowed, right? As is obvious. So the reason we have to be aware is that people confuse a lot of rulings and all kinds of controversy arises. Don't listen to people who write like that. In general, right, there's 2 conditions for transmission of hadith of the Prophet ﷺ that relate to the transmitter, which are uprightness, established uprightness, and number 2, established trustworthiness in what they transmit. And if either one is not present, what they relate to you is not acceptable. Same thing applies to knowledge. Just the fact that Oxford University Press or Brill or Harvard or Yale or Chicago or whatever fancy university published a book, does that indicate anything about the uprightness of the author? No. Does it indicate anything that this person is religiously reliable insofar as the accuracy of what they're telling you? No. Sophistication is not an argument. The most sophisticated of Allah's creation is Iblis. Right? Is Iblis. Right? And most Islamic studies departments, Islamic studies in the West arose as an extension of the ministry of the missionary efforts of the church, and churches, and the imperialist and mercantilist designs of European powers. Not exactly something to bequeath a lot of confidence, right? So the fact that someone is Muslim, right? Would you accept a hadith just because a Muslim said it? You'd have to be a fool to accept a hadith. So I'm relating this hadith to you. Why? I heard my grandfather say it. That's not, yeah, your grandfather's a good person. That's not proof. So someone's telling you a whole theory of the deen, and who is it? You don't know. Well, it seems like a nice guy. I checked them out on Twitter. They have a beard. So do all kinds. Just look at our prime minister now has a beard. Okay? Apparently, I just saw it because Dr. Ingrid Mattson tweeted something about that. That petty people care about those kinds of things, right? So we have to be very, very careful about things like that, right? Because a lot of people get impressed. And we also have sort of this colonial complex, right? Anything that has doctor, PhD, some big deal. Oxford University, oh wow, mashallah. But it's, something is sophisticated, whatever, Shaykh Yahya wrote, I love Shaykh Yahya, right? Shaykh Yahya is now a PhD, right? He's not made any announcement about it. So I was driving with him to a Chinese restaurant, halal Chinese restaurant. I said, so do we call you Dr. Rhodas now? He said, don't you dare. I said, Dr. Rhodas? He says, never. Right? But sometimes, there's an issue, there's a thing that, just because someone, before they're just like a regular sheikh type, now they're PhD. PhD from where? Certified by some, that's not. So we have to be, we have to be aware of these kinds of things. If anything, if one knows the history of these things and the present purpose of these things, if anything, the general rule would make one be even more wary of someone with those qualifications, given, or at least look even more carefully. Do they actually have training? What do the ulama say about it? And this is very important to be aware of, right? Anyways, when it comes to contracts, again, all kinds of people saying all kinds of wacky things. Kitab al-Ijara, the book of hire or rental. Ijara, right? Bay'a, right? Is related to a'yan, right? To things, right? You buy and sell things of value. And it could be intangible in our times, like, copyright, etc., is considered to be intangible items of value, right? It's related to tamlikul a'yan, tamliku al-mal, right? Tamliku malin mutaqawwim, right? And there's a transfer of ownership of an item of recognized value. And the price is the means for that, right? Hire, ijara, is a contract that gives you right to manafi', to the benefit of something of value, right? That's why it's tamliku al-manfa'a lal-ayn. You own the right of benefit, not the item itself. Right? So, and broadly, you can hire a person, you can hire, right, a person or a thing. Could be living or not, that's a secondary matter, right? You could hire a person, you could hire a thing, right? That thing, of course, could be living. You could hire, we don't hire living things that much, but you could hire an animal, etc., or a non-living thing, right? Now, if you hire a person, just to understand the classification, there are different rules related to what's called al-ajir al-khas, which is an exclusive hire, right? There's someone you hire, basically you hire full time. So in their work hours, they cannot do anything else, right? And we'll look at what the rulings are related to that, and there are particular rules related to that. And there's an ajir al-am, where you hire someone to do something for you, like a contractor. And there are rules related to that, right? So someone hired can be hired in two ways. We're talking about people, right? When you hire things, right, there are considerations related to that as well, which we will look at. Just as in a contract, we have to make the key term. In a sales contract, we have to make key terms clear. Likewise, in a hire contract, we need to make key terms clear. Right? And we'll be looking descriptively at what these key terms are. But in many ways, hiring is a little more complicated than selling. Why? Because what is more if I sell you this mic, it's simple in that now what happens once I sell you this mic? I sell you this mic for 100. We're faking it, but just please say you accept. I sell you this mic for 100. You accept it, right? I was joking, by the way, but as soon as that happens, you own the mic, you owe me $100, thing that's done. But let's say I rented you this mic for $20 a month for 6 months. Okay, that was very well done, Faraz. But I rented this to you. Now what happens? When you take it, is it yours now? No. What's the status of the mic in your hands? It's an amana. If you bought it, you could do whatever you want. Yeah, you could unscrew it and toss it around and do whatever you want. You could use it to scratch your back or whatever you want with it. But if you rent it, the item being rented is an amana. So amana is involved. In a hire contract, because what do you acquire by hiring? It's the manfa'a, the use. So a hire contract technically kicks in moment by moment, right? But it is payable according to an agreed upon schedule, right? So that needs to be defined, right? Like how long are you hiring for? How will the payment be made? Because technically, if you rented it for 6 months, with every minute, you owe some of it. But how is the payment due? The default is payment is due on a monthly basis, unless there's a custom to the contrary. But that arises, right? That arises. How will the payment? How is the payment? Is it due upfront, etc.? But the amana, but in contracts of hire, there's an amana with respect to intangible items. But there's also an amana related to contracts of hire. When you hire somebody, both the one hiring is trusted. Why? That if you hire someone to do something, then what are they responsible for? What they were hired for, not for other things. They don't become you don't own them. They're only hired for what they agreed to, unless changes were made. And so the one hiring has an amana with respect to what the person they hired will do, unless they agree to the contrary. And also with respect to the time, not to demand more from them than what they agreed to in terms of time. But there's also amana related to the one hired. Because if someone is hired, they are being trusted to act in the interest of the one hiring them, within the context of their hire. Right? And that's very important. Whether they're in a position of management or not. Like I've dealt with cases where someone got hired and they recommended that someone else be hired, and turns out the two of them were working together on another project. In Western law, this is, if that could be taken to court, that hire was made on the basis of conflict of interest, but that amana applies. That are you acting in the interest of the person who hired you? Where that interest would come in conflict, that is mukhalif lil amana. You have to make bayan of that, make that clear. Right? So recently we hired somebody and they made clear that, I'm providing similar services for such and such project. I said, okay, you've made it clear, so you agreed on that. But a lot of people are not careful about things like this, right? And so this concept of amana is very, very sensitive, and it arises more with ijara. How you use, like when you rent a house, whose house is it? It's not, I live in the house, it's mine. No, not Islamically. You're a renter. What can you do within the house? That which is within the house is a trust. It's not yours. So what can you do? Well, I've been living there 20 years. Well, but it remains a trust. Right? And some things get sensitive. Right? in some places, the laws protect the renter, but the owner wants to sell the house. Whose house is it? Right? Their contract is up. They were leasing for a year, it's up for renewal, and they refuse. They say, well, according to the law of the land does not abrogate the Sharia. You have to follow the law of the land, but the law of the land does not abrogate the Sharia. So the law of the land permits you to take drugs. Does it mean that drugs become halal in the Sharia? No. Okay? So the law of the land protects you from eviction. Say, okay, is this within the bounds of the Sharia, which is, okay, that within the duration of your contract, if the landlord wants to evict you, that's dhulm. But the contract is over and they want to sell. You know, the only investment they have in life is this house. And now they're retiring, they don't have retirement savings, whatever, because they ran a corner store. And now this is the retirement funds they'll have. You manage to ram through living in their home, you're causing someone else harm. Even if you have legal protections in it, right? Law does not, a customary law does not lift shara, does not lift divine law. Right? And never give yourself a fatwa and assume that you're correct. And even the great ulama, what they would do if something had to do with their interest, they would consult others. Sometimes they'd consult the students of their students. One of the great scholars in the Indian subcontinent, late in his life, he had all kinds of health conditions, and he's the author of one of the most famous collections of fatawa, author in the last 150 years in the Indian subcontinent. And a lot of young students of knowledge would be attending to his needs and this and that. And he'd ask them questions related to his tahara, to his prayer. They're like, Maulana, we've studied with your students, or in some cases the students of your students. Why are you asking me? He says, because I don't give a fatwa to myself. Right? Because the nature of the nafs is that it deceives. So ijara has many aspects related to trust. The one in hiring someone, they're trusting you that you will be fair with them. In being an employee, you're being entrusted that you will be fair in the fulfillment of your duties. And in hire, right? And there are 3 levels, and we touched upon it before, but whether you're renting or leasing something or hiring someone, it's useful to remember that there are 3 levels with respect to the rights of others, right? There is al-adl, to be just, to be fair, just to give another their full rights. And then there's the ma'roof, to act in a good manner. And that is recommended. The ma'roof, that there's known good practices. So you follow those known good practices. And number 3, there's ihsan, excellence. Just to go above and beyond. Okay? So that is a little bit of background that we wanted to give related to Kitab al-Ijar. Just one last thing. I don't know if Sidi Shibli has it yet, but if he doesn't, you can check his website, you can tell him to get it. They have, it's Fonds Vitae or ITS has published Imam al-Ghazali's book on earning a living, Kitab Adab al-Ma'isha, from the Ihya. And that's really brilliant and very, very beneficial. So, and it's translated by Dr. Adi Satya, who is a good man. And he has a number of other good translations on things related to mu'amalat. So that's something to. He also translated Imam Muhammad ibn al-Hasan's work on earning a living, Kitab al-Kasb, and some of the writings of Ibn Abi Dunya and Muhasibi on to have a body of literature related to Islamic financial, the ethics and law related to finance, to financial transactions and businesses, because both together, the law plus the ethics, right, together are a key to economic empowerment. But the law on its own just tells you the limits. That, that tell me about marriage. Say, well, don't abuse your husband, don't hit him, don't punch him, don't curse him, don't lock him out of the house. Like, is that a good marriage? No, that's just like, but, so what can I take my wife to court about? The judge would say, well, if she stabs you, if she rips your clothes, and even that, the fuqaha discuss, when can one spouse take the other to court for ripping the other person's clothing? It's only if it's a rip of, that would be a loss of material value that can be taken to court. Doesn't mean that that's sound conduct between spouses, right? Because it could be an accident, right? Someone was doing the laundry or whatever, right? So, but that's not a prescription for good conduct, right? So those are things just to keep in mind, and we'll start next class with the actual section on ijara, but